I can hear you already.
So I have one. I'm not going to
This is the 643rd regular Arizona Racing Commission meeting held at 10 o'clock at 110 West Washington Street, Suite 260. This is the call to order for on April 14th, 2016.
Okay, good morning. Thank you for coming. I'd like to call to order the 643rd regular Arizona Racing Commission meeting. And so I'd like now to ask Madam Secretary to take roll.
Thank you. Commissioner Garay?
Present.
Commissioner Feldmeyer?
Right here.
Commissioner Lawless?
Here.
Commissioner Heupel?
Present.
Commissioner McClintock?
Here.
Thank you. All present and accounted for.
All right, thank you. First of all, I'd like to offer condolences to the Dan Lucianos and his family. His wife, Sidra, had passed away, I think, shortly after our last meeting, and I was able to attend her memorial service yesterday. And having known Dan for years, I can tell you everything I learned about his wife yesterday. I now know why Dan has been such a wonderful person for the Greyhounds, and very sorry for his loss. I know we have several things here today on our agenda, and I'd first like to see is there any objection to moving the line item B to the end of the meeting so that we could get through some of the other items?
So moved.
No problems? Okay, excellent.
You didn't vote on that?
No. Okay, so we'll move on to new business. The first one up is consideration of a 3-year permit for 2016, 2017, and 2018 for Churchill Downs Technology Initiative Company, Twin Spires. Mr. Director?
We have no objection to this. Mr. Stiles, you want to elaborate?
I'll focus. Speak up here for you guys today. Churchill Downs filed their application on January 13, 2016, before their existing permit expired, so they were in compliance with that. Did the sub-review as well as the administrative review. Everything came out fine. Department of Gaming Financial Investigator Andrew Hawks did the background checks on and everything. Everything came out perfect. Our recommendation is for approval.
Is this something they had the last 3 years?
This is something they had the last year.
Just last year?
The very first time that we did the ADW permits, we did them for 1 year only. The second go round, I did it for 3 years.
So then, Greg, this is standard practice that the department goes through with these applicants.
Absolutely.
Okay. I move for approval.
Second. All those in favor, say aye.
Aye.
Madam Secretary?
Commissioner Garay?
Yes.
Commissioner Feldmeyer?
Yes.
Commissioner Lawless?
Yes.
Commissioner Heupel?
Yes.
Commissioner McClintock?
Yes.
Thank you. Motion carries.
Thank you. And just before we get on to the next item, if anyone has problems hearing us, I would just ask that you raise your hand so we could fix the issue, because I know we have a couple of people in here doing some official recording. So again, just let me know if you have any issues, and we'll get that rectified.
Can Cassie please speak up a little bit for me? I'm having a hard time hearing her.
Okay.
Thank you.
See, it worked already.
Yes, sir.
All right, the second item is award of annual adoption grants.
I'm going to stay up here because this is also, as you know, every year we give away adoption grants to both horses and greyhounds. We'll tackle the horses first. One application came in. We've done the review, and the recommendation is to award $2,011 to Equine Encore Foundation. If there's any questions, I'll be more than happy to answer. So the recommendation would be the $2,011.
Any questions, discussion? Okay, I would entertain a motion to grant $2,011 to the Retired Racehorse Adoption Grant, or to the Equine Encore Foundation in Tucson, Arizona.
So moved.
All those in favor say aye.
Aye.
Opposed? Madam Secretary?
Commissioner Garay?
Yes.
Commissioner Feldmeyer?
Yes.
Commissioner Lawless?
Yes.
Commissioner Heupel?
Yes.
Commissioner McClintock?
Yes.
Motion carries.
Now to the Greyhound part.
There was one application for the Greyhound Adoption Grant. That was Greyhound Pets of Arizona. the recommendation is to $735 donation to that entity.
Any questions, comments? Okay, at this time, I'd entertain a motion to grant $735 to Greyhound Pets of Arizona.
So moved.
Second.
All those in favor say aye.
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 Madam Secretary?
Commissioner Garay,
Yes.
Commissioner Feldmeyer,
Yes.
excuse me, Commissioner Lawless,
Yes.
Commissioner Heupel,
Yes.
Commissioner McClintock.
Yes.
Motion carries.
Thank you. And I know all the other commissioners probably would agree with me, but I just want to give my deepest thanks to all those involved in horse and greyhound adoption. You guys do a wonderful job, and it's deeply appreciated by all of us. And I know also staff appreciates all the hard work every one of them do. Item number 3, Santa Cruz County Fair and Rodeo Association request to amend the 2016 race dates.
This is Sonora County, which runs typically on the weekend of Kentucky Derby, and their permit was for 4 days, which typically what they've done is they've canceled the first weekend of the meet. This year, Deb Fellows has asked me to look into the fact of did they have to cancel those first 2 days, and could they run them at a commercial racetrack? So with the help of the AG's office, we looked at that. And so what this is they're asking for an amendment to where they're going to not race live on April 30th and May 1st. Instead, they're going to race their dates at those first 2 dates at Turf Paradise, April 23rd and 24th, and then they will run live on May 7th and 8th. What's at play here is the 2% live fair mutual tax, which will go to the county to help fund those live races.
Any questions, comments, discussion? Okay, at this time, I would entertain a motion to amend the Santa Cruz County Fair Rodeo Association race dates to delete April 30th and May 1st, 2016, and add April 23rd and 24th, 2016 at Turf Paradise Racecourse.
So moved. Second.
All those in favor, please say aye.
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 Opposed?
Aye.
Madam Secretary?
Commissioner Garay,
Yes.
Commissioner Feldmeyer,
Yep.
Commissioner Lawless,
Yes.
Commissioner Heupel,
Yes.
Commissioner McClintock.
Yes.
Motion carries.
Thank you. All right, item number 4 is Tucson Greyhound Park adoption / placement of greyhounds. I believe, Bill Rice, you had comments you wanted to address on this.
Mr. Chairman, members of the Commission, Mr. Director. I'm Bill Rice, the Arizona Greyhound Association. Tucson Greyhound Park has like 450 greyhounds down there. Now that they've introduced legislation in conjunction with Grey 2K to ban greyhound racing in the whole state by the end of this year, it's not a question of if they're going to shut down, it's only when, what date. We're going to have upwards to 300 greyhounds down there to adopt out. Most of those dogs can't go to other racetracks. Tucson Greyhound Park, it's been a rule of theirs for years. They've either paid for some kennel all of the transportation to move these dogs into Arizona. In most cases, at least half of the freight to move them in. Now, the department tells me that the 6 kennel operators down there that have an average of, 70-something dogs, if they quit racing, they have to stay there and feed those dogs until all of them are adopted out. That could take 6 months, sir. All the adoption agents around the country, they're taking all they can take. It's going to take a long time to move those dogs out. And I have a problem with that. This is a legislation that's been created by Tucson Greyhound Park. This should be their responsibility to care for those dogs without the licensee being penalized by losing their license because they cannot afford to feed those dogs unless they keep racing for Tucson Greyhound Park. And to me, that's like slave labor. They're being held hostage there because the department says they have to or lose their license. They can't go work anywhere else. And I have a problem with it. And I would like for the commission to rule that it is Tucson Greyhound Park's problem to move those dogs out. They should be liable to feed them. It costs an operator approximately $1,000 a week to feed each kennel. If they're not working, they can't do that. They can barely do it when they are working. There's other issues I'll bring up about their money in the next number 5. But right now, my problem is all those dogs down there. If a hauler says, I'll move all your dogs for $500, these people don't have it. I was down there Sunday the 3rd and met with them, and they just don't have it. I'm sorry. So you're going to end up, they're going to lose their license. It's going to end up a big mess for those dogs. There's Grade 2K actually has like phony adoption groups they've set up, board members have set up there in Tucson. They want these dogs to be given to them by Tucson Greyhound Park so they can plaster them all over every newspaper in the United States and use it to raise funds. And it's not right what's going on. You guys can't do anything about the legislation. I understand that. But, and it's already gone through the Senate. It goes back to the House for a vote. Probably going to pass. Originally, Turf Paradise and the Horsemen were opposed to it. Got it held up a little. Tucson made a deal. Good business on their part. They made a deal with the Horsemen for a percentage of the money from Turf Paradise. So now everybody's in support of it. It's going to go through, I feel. Tucson will win. What they did was they made a deal with Grade 2K. If they would ban racing in the whole state, not Pima County, but they eliminate the possibility of Apache, a Phoenix Greyhound Park ever reopening. They eliminate that. It's banned as of December the 31st, according to the legislation. For that, Grade 2K would get them protection of the, quote, dome in Pima County for 2 more years, so they sit there and make money off of Turf Paradise. That's the agreement. And I'm not making this up. It's not speculation. It's not opinion. This is a fact. There's a bill out there that states everything I just said. So, and both lobbyists testified at the Senate that they had made an agreement. So, like I say, I'm not making this up. It's for real. And we're going to have a big mess. There's going to be a bunch of people lose their license because there's nothing they can do. They can't even quit and walk out. Even though Tucson brought the dogs in to keep their track open. Now they no longer want to keep it open. And if they don't, that's a business decision. I don't care if they want to shut down. I do care that they included with Grade 2K a ban on the whole state. It's not right. We didn't do anything wrong in Phoenix because they're using everything that goes wrong in Tucson. I'm sorry. The Tucson owners, I can't do anything about it. I apologize for taking so long. So.
Oh, that's okay. And I don't know if there's really anything we can do today, but I think everyone knows I'm the biggest advocate for greyhounds and the adoption. And one of the things that I want to make sure we do follow is that every owner of one of those greyhounds, they have a right to determine where that greyhound goes. I know there's a lot of chit-chat I'm hearing out there right now that organizations are just going to swoop in and haul all these dogs out. There's even one senator stating that they'll go over to the animal control, and that's the last thing we want, because the last time that county animal control had greyhounds, they had fights and injuries and deaths, and that's not good. So I just want to make sure we look into these things and make sure everything is followed. But I don't know if there's any really motion or anything we could take today just hearing this. Mike, was that correct?
Well, yeah, I mean, you could definitely direct the commission to, you can direct the commission to, keep an eye on it and report back or to place it on a future agenda for more action.
Yeah, I would definitely like to have the department staff looking a little more into this, and also, is there leeway for the kennels? Because once the track shuts down, then those kennel operators, they don't have money. They're not going to be able to handle the dogs. So I want to make sure the dogs are taken care of.
Shed some light on this, Mr. Commissioner. Recently, Mr. Stiles and I had a meeting with Michael Racy, the lobbyist for TGP. He assured us that
They are in communication with the kennel owners. They are working out agreements. I asked them to put it on paper and submit copies to us so that we know exactly what's happening with the dogs. They're talking about assisting the kennel owners with the maintenance and upkeep of the animals until they are totally adopted out. To what extent, I'm not real sure. I'm waiting to get paperwork from them on this. I basically told Mr. Racy that we would be holding both the permittee and the licensees accountable for the dog's welfare. So we are on this. We will be tracking every dog that is down there and where it goes.
And just, my request is that the owner of each Greyhound, they should be contacted to find out what they want done with the Greyhound, and they have a right to determine what group the Greyhound can go to. I know there are groups saying they're going to swoop in, and I know many of the owners would not want their dogs going to groups that advocated, like when Juarez shut down, advocated killing the dogs down there as a way to take care of it. That's just not right. So thank you, and for keeping looking into this.
I have a question. I'm not sure who can help answer this, so I'll just toss it out there. First off, 4 and 5 seem like they run together. And what I'm hearing is that the park's going to close. The legislation eliminates the possibility of having any Greyhound racing in any other location in the state. If that's the case, then what leverage does the department have in following through with this if there's no more Greyhound racing in Arizona and somebody has a permit or a license? Doesn't mean anything here anymore anyway. I mean, take me to school. Help me understand what we can do if there's nothing more in Arizona.
As far as the welfare of the animals, to adopt them out and maintenance and upkeep and feeding of animals. Bottom line is that if we cannot hold them to do what's right for the animals during this closure process, obviously there's criminal laws in place that we can implement against either the licensee or permittees. So, that's our ultimate angle on this.
I believe Mr. Rossi, would you like to?
Great. Thank you, sir.
Thank you.
Commissioners, Michael Rossi on behalf of Tucson Greyhound Park. And first I'd like to clarify a couple things. This characterization of winners and losers and our bill and somehow we are winners could not be more inaccurate. Now, I'm not going to take the time this morning to talk through the entire history of what's taken place with the racing industry overall in this state, its decline overall in the state, and most particularly the decline in the Greyhound industry when American Greyhound Racing chose to shut down using an existing provision of the law. They retained their permit. There was an orderly transition and an orderly process for the relocation of the dogs. Precisely the same thing will take place with Tucson Greyhound Park. Should this bill ultimately become a law, we have met with the department and pledged that to them. We have met with the kennels, and I am meeting with the kennels again Saturday morning. We will be talking and meeting with the kennels formally on a regular basis. We will be entering into written agreements with the kennels with respect to helping them out and with respect to the relocation of dogs. We will remain a permittee. The department will retain jurisdiction over the track and the owners and will retain the ability to control, enforce every one of the existing rules and statutes. And this will all be done very openly, very transparently, coordinated with the kennel owners and the dog owners. As the chairman has very rightly pointed out, there are people that own these animals, and that seems to have gotten lost from time to time in this discussion. But everyone will have to work together following all the rules with the oversight of this department and this commission to make sure those animals are properly and appropriately taken care of and relocated, whether it's to a track or an appropriate adoption agency, as it may be. We also have over 100 employees at the track, and we are very, very concerned with those folks as well, and economic impacts to South Tucson. So this is a complicated process. This is not someplace the track wanted to be in by any means, but we've been the only live racing dog track in the state of Arizona for over 6 years now. We have faced constant assaults from the animal rights groups, which have been growing stronger and gaining more and more influence in the legislature, and have made alliances with others in the industry that has unfortunately, inevitably led to this outcome. Should circumstances change, legislature meets every single year. Things that are disallowed are reallowed. If there's an opportunity to bring live racing back in the state, there's nothing that prevents that from happening. I'm not optimistic about that, given the lack of support live Greyhound racing has at this point, both in the state and in the nation. But this is a very, very sad process for Tucson Greyhound Park and its owners, but they pledge to work with everyone to make the very, very best of this situation that they possibly can. With that, I'd be happy to answer any other questions. We will be talking with the department on a very regular basis, keeping them up to date, providing them copies of agreements, and hope to avoid some of the rumor and speculation that is going on behind the scenes, because that's very counterproductive to an orderly process.
Thank you. Just one thing I would like, I've had numerous people asking about the rules for hauling greyhounds out should we have mass numbers of adopted greyhounds, because everyone keeps hearing that Arizona, we require the trailer to be inspected and the person to be licensed. So I would just like to get some clarification down the road as to what the requirement would be for somebody who could do some hauls. Because I know there's several, but I doubt they're licensed here in Arizona anymore. Any comments, questions?
I have a question for the director. Why would Tucson Greyhound Park be allowed to have a permit if they can't race?
Well, bottom line is under the agreements they have with this legislation, they will still be conducting the OTB simulcast, so they would need a permit for that.
Would they just simulcast dog races?
To my understanding, yes.
Mr. Chairman, Commissioner McClintock, American Greyhound Racing has had a permit ever since they stopped live racing and does simulcasting. Currently, TGP also simulcasts the horse races based on provisions of law that will expire 2 years after the end of this, and then it will be entirely up to Coast Paradise if they wish to still contract with TGP to operate that simulcast wagering in TGP's off-track betting locations in Pima County, or at that point in time they can elect to open and operate their own independent additional wagering facilities. But the precedent has existed now for years, and last year or the year before you renewed American Greyhound Racing's permit, even though they haven't live raced for over 6 years.
But they only simulcast dog races.
And that would be the same case for Tucson Greyhound Park after the expiration of the law. We're trying to do a transition that's helpful for everyone, candidly. And Mr. Sims and I can agree to disagree on this, but the cost of operating those OTBs is significant and probably less for TGP than it will ultimately turn out to be for them. So everyone makes money on that arrangement. And this allows us to try to ensure that there's an orderly transition, but in the end of 2 years, that will go away, and there will no longer be any requirement that they have to contract with us.
Anything else? And again, just for myself, I just want to make sure that, you know, we do everything properly, not a single Greyhound is harmed, and also all responsible are held accountable. You know, I don't think the kennel owners should be 100% held accountable for this situation. There's a lot of parties involved. I mean, heck, if Grade 2K was under our jurisdiction, I'd be saying they should be held accountable for this as well and coughing up some money. But unfortunately, they're not. But I just want to make sure everything is done right, and, you know, let's look into everything we can to make sure it's proper and taken care of.
So, a point of clarification, Mr. Chairman, if I may.
Sure.
For the record, Vincent Francia, General Manager of Turf Paradise. The point of clarification, since it was mentioned in previous testimony by one of the speakers that Turf Paradise is in favor of this legislation, which is known as HB 2127. Turf Paradise is not in favor of this legislation.
And I'm sorry, Vince, I meant to mention that as well when I heard someone else say that. Yeah.
And you call yourself a good lobbyist. No, he's a great lobbyist. So. All right, thank you. I think we now getting old. Next item is Tucson Greyhound Park permit, and I think Bill, did you have Mr. Rice?
Again, for the record, Bill Rice, sir. Tucson Greyhound Park, when they applied for their permit, there was, I don't know, 20, 30 minutes of testimony from, I guess you could call it a financial officer for the department. I don't know.
Yes.
Okay. Anyway, he painted a pretty grim picture before this commission of the financial condition of Tucson Greyhound Park. At the very end, he said that he had the personal assurance of the two owners that they would fund all losses through the length of their permit, which I believe runs till September of 2017. They were going to raise, fulfill their permit when you guys voted on it. I think that was a fraudulent application. I don't think this commission would have approved the permit had the financial officer not said that he had the personal guarantee of these owners. I'll give you 3 instances. I was down there on the 3rd with a meeting with Mr. Rossi and the kennel operators. The previous Monday, one of their piece of equipment's been broke down for months, the kennel operators tell me. The tractor wouldn't finish dragging the track, so they had to cancel races. That cost the kennel operators. They got the simulcast. They ran their horse races. The kennel operators did not get paid that night. That's 25% of what they would normally make a week. They race 4 days a week. They lost that night simply because they wouldn't take care of their tractor. They owed a hauler almost $7,000. I had to go to the department, find out the proper procedure for him to file with the department and the stewards for him to collect his money. He finally, last week, Mr. Pott did send him a check for a little over half of it, agreed to send the rest pretty quick. But they only did something after we went to the department to get advice on how to collect their money. Last fall, the kennel operators had a contract. I'm not going to take the time, sir, your time to explain the point system on the way greyhounds are paid. But they had a contract for the year. They would pay the kennel operators $16 a point. Last October, the owners were losing money subsidizing the races. So they went to the kennel operator and said, we're either going to shut down or you're going to take $13 a point. Kennel operators had no choice. They're in the same boat they are right now. You're sitting there with $83. What are you going to do? Since that time, they have lost. Mr. Rossi was informed by one of the kennel operators, after paying the commission to the owner of the Greyhound, since that was implemented, she had actually lost $7,500 of what she would have been making. She couldn't even make her house payment this month because these people are broke. Tucson is broken. They have not taken care of that racetrack. You guys sit here and went through 2 or 3 months just arguing about the rail with the chief steward down there because it being unsafe and dog get killed. So they have not fulfilled their permit. I think that you guys, and I don't know what other word to use. I'm not articulate like Michael is. To me, you were lied to, and that's what got your vote for the permit to start with. And I think they are in violation. If that permit, which this commission controls solely, there's due process if you guys were to revoke the permit. I understand they would go to Superior Court and do all that. It takes a while. And there should be due process for everybody to be fair. But this commission controls a permittee's permit. This is your authority in this state. You are the authority in this state over a permittee. And I think that you guys were lied to, I'll be honest with you. I really do. I do not think they would have got their permit and their financial condition. The department was reluctant in recommending it. The financial officer only did it because he had the personal assurances that the owners would pay. Then they passed that loss down to the kennel operators and broke them. I mean, they were already running for peanuts. Tucson is the bottom of the line track. That's why we have so many dogs that can't go to other racetracks. They're not good enough quality. They're the bottom. But these guys are broke. I sat down there with people I've known 30 years, Sunday a week ago, and it was sad to sit there with them, the way they're beat up and beat down, and now they can't even quit and walk away and go get another job. I do not think Tucson Greyhound Park has fulfilled the conditions of the permit that this commission granted them. And with that, I'll be happy to answer any questions, sir. Otherwise, you can hear from Mr. Rossi.
Any questions, comments, or so?
Mr. Chairman, members of the Commission, Michael Rossi again on behalf of Tucson Greyhound Park. I've known Mr. Rice a long time. I consider Mr. Rice a friend. However, coming up in front of you and making criminal allegations of fraud is incredibly serious and incredibly inappropriate. No one was lied to. No fraud was committed. The entire industry is struggling. You know it. I know it. Mr. Rice knows it. That's why American Greyhound stopped live racing. State statute says they are to pay into purses out of their simulcast 4%. But in negotiations with the dogmen conducted by Mr. Rice, they reduced that to 1% many, many years ago. Everyone is struggling. Everyone is trying to make the best of a very challenging situation. The audit that was conducted last year said that without additional infusion of cash, the track would have trouble continuing as an operating entity. I came and spoke to all of you on that item. The owners of the track have routinely subsidized the track when and as necessary, and those same auditors, in doing a review of the owners, concluded that they are well able to do that. The bill for the hauler was paid having nothing to do with anything from the department, Mr. Rice, or anyone else. So again, we will continue to be here, work with all of you, and respond to any questions and any concerns that the director, the department, or this commission has. And I thank you again for your time this morning.
I just have one question, and just for the record, I've known you and Bill Rice, both of you, for a number of years, and I really like both of you. The only question or comment I have is I do feel like we were a little bit misled when the permit was requested, because there was the guarantees, we thought, by the owners to handle any losses. And I fully understand struggling, but struggle is part, if you're losing, there's struggles there. And I know a couple of the kennels down there, before they invested money into running a kennel down there, they were asking, are we getting a 3-year permit? And after the vote here, I was able to tell them, it's like, yeah, you've got 3 years to run, and now this. And also, I'm just gravely concerned that, when you have a permit, you're supposed to do everything that's in the best interest of racing and get involved with an organization from Massachusetts that knows nothing, I repeat, nothing about Greyhound racing, proper care, proper regulation, proper licensing, or anything. To me, that is just not doing what's in the best interest of Greyhound racing, and then proposing a bill to ban it nationwide. Now, I keep hearing this, well, down at the legislative, they change things all the time. As a citizen of the state, I can tell you, that concerns me when I hear a senator down there say that, because we always hear, oh, we're going to create this new tax and it's going to be sunsetted. They never sunset anything down there. That was just garbage in my mind. So I do have concerns. I'm not making any accusations, but I do have grave concerns, and I think the department, I know we really can't act on this, but I do think I would love to instruct the department to look into this a little bit, to find out if we were misled and what could be done, and any associations with organizations that have nothing to do with Greyhound racing and are, there's a lot of rumors that this organization has ties to the Animal Liberation Front, which the FBI has deemed to be a domestic terrorist organization. Why are we having a permittee, if that's the case, involved with an organization such as that? I think an investigation needs to be looked into and get back to us with a report.
Mr. Chairman, Commissioners, we are more than happy to have the department look into anything they would like. We will cooperate and participate in anything they would like. But I want to, on the record, right here, say unequivocally, you were not misled about anything. This is not an outcome that we planned or desired. However, the track has been under assault, as you know better than almost anyone, for years. We have a city council member down there that is on a mission to close the track. We have multiple organizations that are aligned against Greyhound racing. Others have been assisting them, and sadly, this was something that appeared was going to happen sooner or later. The degree to which we are working through the legislative process, and this is not our bill, that's not how the process works, has been to try to do this in as orderly a manner as possible. American Greyhound Racing had existing law that allowed them to shut down in an orderly manner and continue simulcasting. We're attempting to accomplish the same thing in light of a very challenging political environment. I could spend a couple hours going into more detail on that. I'm not sure that's necessarily appropriate, and I'm not asking you to sit through that. But there is a lot that has gone into this very, very difficult decision, and it's made within the context of that legislative process up the street that does things we don't always love.
Good morning, Ed Bronger, General Manager of American Greyhound Racing. Just would like to clarify one thing that's been battered out a couple times. We closed down 6 years ago, and we did. And we are simulcasting now. But we did not put a bill out not allowing live greyhound racing in the future. And I just want to put that on the record that we closed. If Tucson wants to close, they should have closed. Why we have to have a bill out there to not allow future greyhound racing? That's a question we all have to ask. I just want to clear that out, that we did close for financial reasons, but we didn't put a bill out there to not allow to bring back live railings. Thank you. Any questions?
Any comments, questions? Again, I would just like that, you know, if you get a chance to do a little more digging into this, maybe if the next meeting get back to us with what you can find out, so then we can maybe take action if needed be. Thank you. And my question for you is, should in the future, if we ever able to bring back Greyhound racing, can I hire you to get it done?
Yes, if you can. And please understand, I wasn't going to. Not our choice to include the provisions to eliminate live racing. Not our choice at all. Thank you, Commissioners.
All right. The next item is D, information reports, and is Eric here for a legislative update, or are you Eric now?
Yeah, I'm Eric today. For the record, Greg Stiles again. Two major pieces of legislation. The first one is Senate Bill 1435, which is the Racing Commission. That is has now passed, if I'm correct, through both houses, and actually went back to the Senate one more time. So I think they'll have some work on that. That does continue the Racing Commission for 8 years. One of the provisions in that was 35% of our RWA revenue was going to go to the Breeders' Fund, but that has been taken out. Still in that is the 2% live mutual pari-mutuel tax. That is still in there. And your guess is as good as mine as whether that stays in there or not. But, I'll anticipate at this point in time that it will be there. Second piece of legislation, which we've been talking about all morning, was HB 2127, which is the elimination of live Greyhound racing. That passed the Senate this week. It's gone back to the House because there was a floor amendment done, so it'll be to a House vote, or they can concur, and then that'll move on to, I think, the governor's office at this point in time.
Greg, why was the Breeders' Fund removed?
I will have to, since I have not been a legislative liaison for the past year, I had not filed the bill as well. I was just given the duty to do this today is to give a report, so I haven't done any research on it. If you're asking why was 35% removed?
And then what has it been replaced with, if anything?
From what I understand, the 35% has been taken out of the bill. Okay, at first, when it was first introduced, it was the 2% of the live pari-mutuel tax and 35% of the RWA. The 35% of the RWA has been removed.
So then the 2% would be dedicated to the breeders?
From where it stands right now, that is correct.
And what, just roughly, kind of revenue would that produce?
I think the last figure I heard, it was like 181,000 around there. I don't have a specific number, but I can certainly get that for you.
So it would go from
186 as well.
So then, to help me track my memory, it was substantially higher than that by several $100,000.
If you would have done the 35% of the RWA, you would have had a substantial amount.
Would it have returned to the number that it was in previous years?
I'd have to look back, but I don't have that information at this time as far as what the top figure was. And I apologize. I was kind of...
No, that's all right. More than anything else, I'm trying to find the pattern.
And I can get that for you. I'll be more than happy to do some research for you and get that, because that data is going to be available.
All right, thank you.
Might be nice to know how many dollars per horse bred that works out to the old days versus now.
I can do that additional work as well.
Thank you, Greg. Okay, next is permittee reports, not to exceed 3 minutes. American Greyhound Racing.
Nothing to report this month.
County Fairs.
Good morning. My name is Sharon Denham. I'm president of the Arizona County Racing Association. Just here to give you guys a real quick report on what's going on with us, and a bunch is going on with us. So it would be, I'm not going to, I could be here for 3 hours telling you everything, but I'm going to do it in 3 minutes. We have 3 county fairs up and running and ready to go. Safford at Graham County is running the 23rd and 24th of April. They will primarily be running the trials for our stakes races, and then they also have some additional racing involved in that. But that's going to take up quite a hunk of their 16 races. 8 races a day, 16, and we are ready to go. Sonoyta will be opening on the 7th and also the 8th. They have the Kentucky Derby weekend, of course, and they've got their big screen set up, so all their folks that come in from Tucson and around the area will be able to literally feel like they're sitting on the stretch of Churchill when they see those thoroughbreds come down that big screen. It's really exciting. Douglas, May 21st and 22nd, we will be hosting the finals for all of these stakes races, and some classic, what we hope to be classic races that are identified with some of our local famous horsemen down there, and also some cultural traditions are going to be woven into the names. For instance, the China Poblana Stakes. The China Poblana is a famous Mexican heroine that was part of the Mexican Revolution. We have a race named for her. We've got the Relámpago, which was the horse that really won the El Moro de Cumpas, and of course the El Moro de Cumpas Stakes itself. So it's lots of fun. We have a condition book out, and I would ask you to take a look at what it looks like. It's on the website of Racing Across America, TRS, and also it's on the El Moro Stakes. The stakes race is also on the El Moro website, and we would encourage you to look at those and be able to get an idea of the types of races that we're going to be putting on. We're very proud of the quality of racing that we are going to have at county fairs. This is a big step up from what we have previously offered at county fairs. Jim Collins is our racing secretary, who's back and forth right now, helping us from Sunray. He did all the organization, been working on it since October. So a lot of work and a lot of expertise into it. All the tracks are open and ready for training right now. Safford had some heavy rain this last week.
We'll need to wrap this up quickly.
Oh, I'm sorry. Excuse me. All right. One other thing I wanted to mention, as of tomorrow, all 3 of the tracks will have finished their official surveys from the county surveyors who come out and determine the exact distance, the slope, and all of the technical things that go with putting a good race together. Thank you very much.
Thank you. It's exciting to hear the things coming out with the county fairs. I don't know if all the commissioners had known previous commissioner and had been Chair Kruglich, but I think he would just have been, if he was here today, he'd be really excited hearing all that. So thank you for outstanding work.
I forgot something, and something very important. We have one of the Board of Supervisors with us this morning, Robert Corbell from Greenlee County. Greenlee is planning to open their track and be ready to race next week, and I'd like to introduce Robert Corbell to you from Greenlee County.
Hi, y'all. Thank you for letting me come over here. I appreciate it.
Thank you.
We get horse racing back in Greenlee County 1905 since the last one, and we're really looking forward to it. So thank you very much.
That's exciting news. All right, the Rialto, anyone going here from there today? Okay. Tucson Greyhound Park. Oh, there's where Dell. You were up here and you disappeared on me.
Dale Pop, General Manager, Tucson Greyhound Park. I normally sit in the front and I wear hearing aids, so I'm kind of only halfway catching a lot of what's being said. keeping up with most of it. First of all, let me reiterate what I've said pretty much every meeting, that my priority is the safety of the animals. Should House Bill 2127 become a reality and we have to deal with the transition of relocating the Greyhounds, number one importance will be the safety and well-being of the dogs. You have my commitment, what I can do on that part. Also wanted to give you an update. In the past, we've had issues with the roof and different things at the track. Currently, all roofs have been repaired. Everything's in good shape, thankfully. There was a small issue with a couple of braces on the inner rail. The last time we had the meeting and I spoke of that, that has been corrected. I personally have gone around to every brace on the track and made sure that everything is 100% connected and no issues whatsoever. We have updated some of the lighting on the scoreboard. The point I'm trying to make is, even though it looks like there may be an issue we have to deal with the end of live racing, until the last day of live racing, I will stay on top of this stuff and make sure that there aren't any issues due to neglect that will pop up. So again, the dog safety and relocation, if it comes to that, will be top priority, and I will do everything that I can to make sure it's done right. Any questions?
Just thank you. No matter whatever happens with the bill, I do want you to know I appreciate everything you've done down there. I appreciate both you and Alicia, the hard work you guys do, and I know you guys do care about the dogs. So thank you for everything you've done.
Thank you, and all the commission, thank you for putting up with me all of this time. Thank you.
All right, Turf Paradise.
To be identify myself, Vincent Francie, General Manager of Turf Paradise. The 60th racing season is quickly coming to a close, May the 8th. It'll close with a bang and not a whimper. Ever since we had Wiener Day, we drew 9,800 people for that. We raised over $22,000 for Greyhound adoption. 2 weeks later, we had alternative race day with the camels, ostriches, and zebras. A crowd of 10,200 showed up for that. And now Derby Day, which is scheduled for May the 7th, we are already sold out in our buffet levels from the director's suite to the turf club and down through the clubhouse. And we're adding a tent this year in the picnic grove to accommodate additional 400 Derbyites. With the season coming to a close, Turf Paradise wishes to thank the Commission, the Racing Commission, for your continued support of parimutuel racing, specifically the sector I represent, the horses, to Director Casillas for maintaining an open door policy with us to answer our questions and concerns, and to hosting numerous stakeholder meetings, and last and certainly not least to the Arizona Horsemen's Benevolent Protective Association, the HBPA, specifically Tom Menson, the Executive Director, and President Lloyd Yother. Communications were at an all-time high, but specifically when the track was threatened by the equine herpes virus, decisions had to be made. I was making most of them that were inconvenient to the horsemen and causing additional expense, but decisions that had to be made in conjunction with the HBPA to protect the race meet and the horses in the stable area, and would not have been able to do it without the help of the HBPA. So, thank you.
Yeah, excellent on everyone's who worked on that, on protecting the horses. You guys just did an outstanding job in the department, everyone. Yeah, I think other states that have racing going on could look to us for how it was handled, and because you guys did an outstanding job, not a single death, and were able to keep racing, and the 6 horses were taken care of. So thank you, everyone, for looking out for the animals. All right. Okay, optional industry stakeholder association updates, not to exceed 3 minutes. The Arizona Greyhound Association.
Nothing more, sir.
Arizona Quarter Racing Association.
House.
Yeah.
Good morning. My name is Loretta Brazier. I'm the Executive Director of the Arizona Quarter Racing. First of all, I want to thank you guys for your grant for Patty. I know she's not here to thank you personally, but for Equine Encore. And another thing I'd like to do is to congratulate the Arizona County Fairs. They've worked very, very hard, and as you heard, they have a lot going on. We have 3 racing going on, and the prospect of more next year if they can get their funds together. They've worked very hard out there, and I want to commend them. And like you said, Mr. Kruger could have been here. He'd have been dancing around because that was what he really, really liked. In the Turf Paradise report, they were talking about all the different things that went on. Last Sunday, we had a festival there, and we had 6 quarter horse races, and about 6,000 people on the grounds, I think I was told. It was a very fun day. We are also winding down up there. Our last day will be May 1st, where we will have the finals of our Desert Classic futurity that will have over $72,000 in the purse, and the finals also for our challenge races. So I too would like to thank everybody for how well everything has worked this year. It seems like with all the problems with the virus and the economy and everything else, that we've all kind of worked together really, really well. So I too would like to add my thanks. Thank you.
HBPA.
You forgot.
Oh, I did. Yeah, I'm mixing thoroughbred and quarter horse together, you know.
Hi.
I'm a dogman. I don't know horses.
My name is Dove Ward. I'm the Executive Director for the Thoroughbred Breeders Association. I just wanted to say that next week we will be honoring our 2015 champions at our awards dinner on Friday, April 22nd. The following day, Saturday, will be our Breeders Festival. And it's our day of racing, and it includes a $50,000 Derby, Gene Fleming Breeders Derby, and we'll be looking forward to a fun day of racing. Our final race will be the ATVA Sales Stakes Futurity, which will be ran on closing day, May 8th. And I also wanted to thank the ADOR for giving Patty awarding her a grant. She takes care of 77 horses down in Tucson, along with a lot of other animals, cats and birds and everything. And we're honoring her at our awards dinner. We nominated her for the Thoroughbred Charities Association, so she'll be receiving a nice honor from that association for taking care of retired racehorses. So that's all I have to say. Thank you very much.
Thank you. Okay, now the HBP.
Chairman and Commissioners, my name is Tom Hudson. I'm the Executive Director of the HPPA. I really don't have much to report. Firstly, I would like to thank your staff because we've been well received all year by the Director and Greg, and we appreciate all the help we've received over the year and from the Commission itself. I would like to, again, repeat about the herpes infection. It's not only us in the track, but your staff and the veterinarians did a great job. And we have been contacted by other tracks around the nation because we handle this thing pretty good, compared to what's happening around the country. One other item I think I just want to correct. Bill Rice said there was an agreement made with us with under the bill 2127. We've made no agreement with anybody on any money or funds that may or may not come out of the closing of Tucson Greyhound or the Greyhound racing. And I guess that's about it. And we are wrapping up everything. And if you get the opportunity on the 23rd, like Dove said, that's a good day of racing for all the Arizona breds, and you get the opportunity, come on out. See you. Thank you.
Thank you.
Thank you.
All right, Jockeys Guild. 4.5 years ago, I don't think there's ever been anyone from there. Okay, Arizona Counties Racing Association. Okay. that wraps that up. So then I guess should we go back to...
You might consider doing a call to the public for anyone who might not stick around for the rest of your meeting. There might be nobody. But.
Well, we had 3 names on for call to the public. I know Bill and Michael, you had signed up for C4 and C5. Are you guys both done? And then Stacy, you're signed up for B1, 2, and 3, which would be the next item. So I think we're good on that. So. All right. Does anyone need a quick break before we jump on to the next item?
You can if you'd like, sir.
Okay, I'd like to just take a quick 5-minute break so we can people can take care of business before we get on to the next business.
Pausing at 11 a.m.
Back to order. We need to do a roll call.
No, we are back on the record, and it is, 11:13 a.m. And I can go back through the roll call for you. Commissioner Garay?
Present.
Commissioner Feldmeyer?
Still here.
Commissioner Lawless?
Here.
Commissioner Heupel?
Here.
Commissioner McClintock?
Here.
Thank you. We're all present.
All right, thank you. Before we get to the items B, 1, 2, and 3, we still have one item, E, commission reports I'd like to just hammer out before we get into the other items. And the first one is summary of current events affecting the Arizona Racing Commission. Is anything to report there?
No.
The only thing, I do know that the Kentucky Derby is coming up, and there is a chance that there could be more than 2 commissioners on site. So
I will prepare and have posted the same notice that we did previously in previous years.
All right, thank you.
So you'll be covered.
And what, the event that for the quarter horse racing that Doug was having, is there going to be more than 2 commissioners at that? Thoroughbred, I'm sorry. And I thought I saw her come back.
What were you asking?
Will there be more than 2 commissioners at the awards dinner?
I don't think we can invite you now because you're under the gaming.
Okay.
Sorry.
All right. Well, hey, that's cool.
Sorry.
I would
have brought anything.
Okay, no. I just want to make sure we were covered there. And then number...
I don't know. We can't have a discussion with her about it, but
yeah.
I'm not familiar with that either, but I don't represent gaming.
And next item is identification of matters to be placed on future agendas. Anybody have anything? Okay, I think we're done, and we know where to find you if we need you.
Okay.
Thank you. All right, the first item we're now going to is B, appeals of director's decision and special action. And the first one is Sims versus McClintock. And at this time I would entertain a motion to go into executive session so we can get some advice from our counsel regarding item number 1.
Mr. Chair,
yes.
May I address the commission before you vote to go into executive session?
Not at this time. We will wait till after when those times come up. Thank you.
I move we go into executive session.
Second.
All those in favor say aye. Aye. Opposed? Okay, thank you.
Okay, we are now in executive session, and the time is 11:16 a.m. This will be the second open session of the Arizona Department of Racing 643 Regular Racing Commission meeting held at 1110 West Washington, Suite 250, Phoenix, Arizona on April 14, 2016.
Right, it's 11:50 and I'm calling us back into session. Do we need to do a roll call, or are we good?
Yes, sir. Let me do the roll call just to make sure that we have everybody present on the record. Commissioner McClintock?
Yes.
Commissioner Heupel?
Here.
Commissioner Garay?
Here.
Commissioner Feldmeyer?
Still here.
Commissioner Lawless?
Here.
Okay, we're present.
All right. Stacy, I know you had signed up for under call to the public for 3 items, and for the call to the public, we're limited to 2 minutes, so that would be 2 minutes for all 3 items. So I don't know if you would would like to talk now or would like to save your 2 minutes for...
Let me just announce myself.
Okay.
This is Stacey Harrison on behalf of Ron Sims. I'd actually like more than 2 minutes, given the presentation and the length of the motions that we filed. However you want me to address it.
Well, I'm guessing at some point in time there could be discussion on the other items, but this was for you had signed up for the call to the public, so I just wanted to know if you wanted to use you had signed up for item 1, so didn't know if you wanted to go ahead and speak about that right now, but
I would like to speak about item 1 right now.
But you're limited to 2 minutes for all 3 items, so...
So if there's discussion, I get more time? I just want to understand.
Yeah, if we have items later on, there could be discussion that we would grant you time.
All right. So are you granting me time on B1, or is it only for the public comment?
Well, it would be on B1 under call to the public, but you have to keep it under 2 minutes. If you go over 2 minutes, then you would not have time for 2 or 3.
With respect to B1, it's a powerful and undeniable fact that the administrative law judge exonerated Ron Sims of all of the factual and legal allegations against him in the notice of denial that was issued. The notice of denial was issued, as you have probably seen in the papers, after a 2-year secret smear campaign conducted by Jerry Sims and his representatives, which culminated in Jerry Sims' representative and lawyer, Mel McDonald, the former chair of this commission, secretly drafting the notice of denial and certain language in it that was ultimately issued. Jerry now comes before this commission. The ALJ reversed the notice of denial and granted the November 20th, 2013 license application. The Director Casillas, ADOG Deputy Director Casillas, deferred to that decision, and at a meeting on October 8th, and I quote, he stated, knowing that the ALJ, being an attorney, independent body, listened to all of the facts of the case, all of the evidence that was presented, and I did not disagree with his findings of fact and ultimate recommendation. That is why I did not modify or reject the decision. Jerry, TP Racing, and Jerry's company, Bell, we call it the Jerry Group, comes before you today to appeal the decision. We have challenged both here and in a special action the Commission's jurisdiction and the Jerry Group standing to bring this appeal. With respect to B1 only, your counsel has probably advised you that the court has declined to exercise special action jurisdiction over those issues. As part of her argument, your counsel stated that the special action should be dismissed because we have not exhausted our administrative remedies on those issues. As such, we have filed an amended motion on both jurisdiction and standing, and we request that the Commission set a hearing on that motion. It's not on today's agenda, but on a subsequent date prior to the consideration of any merits, assuming, of course, the Commission does not dismiss the appeal today. Thank you.
Thank you. And just for the record, for any other items that you had signed up for, you now have used your 2 minutes. So.
Thank you. I hope you allow me to have discussion on the motions to dismiss that are on B2.
Thank you. I don't think we needed any motions or anything on item B1, so we can, with B1, so we can move on to item 2. B2, Ronald Sims, motions to dismiss dated September 2nd, 2015. And
Mr. Chairman, I would like to go into executive session to receive legal advice regarding this. And that would so move. Second.
All those in favor say aye.
Aye.
Okay, the 11:55, we are going out of open session and into an executive session.
Now, do we have to leave our phones here?
No. This is the third open session of the Arizona Racing Commission meeting, 643rd meeting on April 14th, 2016, held at 1110 West Washington, Suite 250. And the time going back into open session is 12:06 p.m. Okay, gentlemen, I'm going to do a roll call.
What would this?
We're not in at 12:06. Hold on. I'll do a roll call, gentlemen. Okay, the time for the beginning is 12:07 p.m. and roll call is Commissioner McClintock. Here. Commissioner Heupel.
Here.
Commissioner Garay.
Present.
Commissioner Feldmeyer?
Yeah.
Commissioner Lawless?
Here.
Thank you.
All right, welcome back, and we are on the item. We're going to address first motion number 1, which is this commission has failed to follow its own rules to adopt rules governing these procedures. So I'd like to open up the floor for discussion. The commission right now. There no discussion?
Mr. Chair, may I address the commission?
I'll give you 2 minutes on this one motion.
It's undeniable that Ron is entitled to fair and impartial hearing here, which includes fair and due process of law. Jerry admitted as much when he appealed the denial of his gaming license, and he stated to the Superior Court, that he was owed due process in the appeal proceedings with respect to the denial of his license. The Jerry group somehow thinks that we're entitled to less due process because this is before a commission as opposed to being before a court of law. That is simply not true, and it is telling that the Jerry group opposes Ron's right to a fair hearing, suggesting that if the commission does not stack the hearing in the Jerry group's favor, it will lose. This commission, as a neutral government body interested in the fair regulation of racing, should not contemplate for a moment proceeding with a hearing that is not fair or impartial or in adherence with due process and fair process. Doing so would be at odds with the commission's mission and responsibility to the state and racing community. The commission should refuse to have any hand in an unfair partial process that the Jerry group urges. Ultimately, this commission has been tainted by the violations of due and fair process that have taken place so far. They are detailed in our motion, and it has resulted in ad hoc decision-making, improper notices, violations of the open meeting laws, also refusals to disclose ex-parte communications that we've repeatedly asked for, and has been irrevocably tainted by considering matters outside of the record, particularly in deciding that the Jerry group has standing to bring this appeal based upon material outside the record and fear-mongering, such as accusations that Ron wants to destroy racing in Arizona, which is flatly not true. A party cannot be subjected to having its rights in a quasi-judicial forum, which this is. It's not simply a regulatory body right now. You're a quasi-judicial forum without having rules adhered to, and we request dismissal of the appeal as a result of this. Thank you.
All right, and since I gave you 2 minutes, I'll give you Jerry's representative 2 minutes as well. And when you kind of see me doing this, that's kind of my warning that the 2 minutes is up. So,
thank you very much. I don't even think I need 2 minutes. My name is Jim Torrey. I represent TP Racing, Jerry Sims, and Bell Racing. We've never argued that Ron Sims isn't entitled to fair process. We want fair process too. And this is our appeal after all. But fair process doesn't mean judicial process. This is in court. The cases are clear that Ron is entitled to notice and an opportunity to be heard. And he has that. He's had notice of this appeal for a long time, and he's going to have an opportunity to be heard. He's going to be able to brief as much as he wants. He's going to be able to argue for an hour on this appeal, and that is absolutely fair process under the law. You think about the Court of Appeals. If you file an appeal in the Arizona Court of Appeals, you have a page limit on what you can file, and then the Court of Appeals may or may not give you a chance to make oral argument at all. Ron's getting way more than that here. What he wants you to do is make up a set of artificial rules that don't exist so that he can tell you later that you violated them, because that's what he does. You talk about a smear campaign, that's what he does. There have been no rules that have been violated. He's had due process. Thank you.
Is there any further discussion with regard to motion 1? Do we need to take a motion on that, or can we move on to motion 2?
You can move on to motion 2.
All right, motion 2 is a violation of Arizona's open meeting law. Any discussion or any comment from either parties for 2 minutes?
Mr. Chairman, in our amended motion, I don't know if you have that in front of you, our motion number 2 is that the Commission's findings and decisions with respect to the appeal have been unlawfully based on material outside of the record on appeal.
Yeah, that's not what I have. Or that's the agenda. Here's the. Oh, hold on. I'm sorry, I got the wrong stack of paper.
No problem. And this is the
original one. This is
Okay, yeah. Motion 2 is the commission's finding and decisions with respect to the appeal have been unlawfully based on material outside of the record on appeal. So, okay, any discussion, or we want to hear from both parties? And again, 2 minutes, and when I kind of go like that, that's let me know we're at the 2-minute warning.
This is Stacey Harrison on behalf of Ron Sims. Again, I don't have much to add to this. I think it's all fully briefed in the papers. Again, there's been a lot of discussion outside the record with respect to the Jerry Standing issue and other issues, and as a result, the commission has been tainted and cannot fairly decide this appeal, and we request dismissal.
We addressed this in more detail on our brief, but I'm just going to talk about it briefly. Ron says you considered materials outside the record. Ron is defining record in a very narrow way. He's defining record as materials that were presented to the ALJ. That's not the record in any sense of that word. The statutes don't provide for it. The statutes say that the commission will review the record. You should do that, but it doesn't say you can't review anything else, and it doesn't define record as ALJ record. Moreover, the issue of standing wasn't even an issue in the ALJ proceeding, and we weren't a party in that proceeding. So there was no evidence at all presented on that issue. It would make no sense to say that we were limited to a record in which we weren't a party, in which the issue wasn't raised. I mean, you want to talk about a due process violation, that would be it. And I'll also note that in all of Ron's motions, see a big stack over there that you have, Commissioner Lawless, most of those 84 exhibits that Ron filed were not admitted in the ALJ proceeding. So he has a bit of a double standard. When he wants to put evidence in, it's okay if it's outside the record. It's just not okay for us. It's a non-issue. It should be, I think, an easy one. Thank you.
I can use my 2 minutes. May I briefly respond?
Sure.
Thank you. This commission has already stated that it will only consider material within the record. The Attorney General Handbook defines the material in the record that admitted at the ALJ hearing and nothing else. This is an appeal, as the Jerry Group has stated. This is not a hearing. This is not an opportunity to bring in new evidence. A court of appeals only considers material that is below, that is in the record before the trial court. As such, you should only consider materials that were presented in the administrative law hearing. Jerry is mixing apples and oranges here in terms of whether, of course, when we challenge due process, none of that's in the record because that's regarding the commission's conduct and those issues. That wasn't in the record below the ALJ. However, standing is based upon what happened in the notice of denial in the ALJ, and that's why those materials need to be within the record. Thank you.
All right, thank you. And I believe you still have a few seconds if you wanted to, or are you done?
The statutes give this commission jurisdiction to decide an issue, and they also say when you have jurisdiction to decide an issue, you can examine the facts necessary to decide that issue. And so on standing, of course, you have the right to examine the facts that deal with standing. Thank you.
Thank you. Do we have any discussion? Anything further to add? And hopefully I'll have the right one this time. We're on to motion 3. The Jerry Group ex parte communications and the failure of the commission to timely disclose other ex parte communications with the Jerry Group has denied Ron fair and due process of law. Do we have any discussion on that? All right.
This is Stacey Harrison, and again, I urge each commissioner to disclose all of your business and social relationships and communications with Jerry and his representatives during 2015 and 2016. The Jerry Group argues that the only communications that you need to disclose are those that explicitly relate to the merits of the proceeding. That does not make sense because it will not allow us to understand the bias, if any exists, of each commissioner. And case in point is a calendar entry that was produced by Commissioner Lawless in response to a subpoena in the TP Racing case. This calendar entry does not explicitly refer to the merits of these proceedings. the merits of the appeal.
Can you swing that?
Yeah. Sure. And also, you have booklets in front of you, and this is page 4 in your booklet. This calendar entry represents exhibits that Mr. Lawless had dinner with Jerry Sims the night of October 7th, 2015, the night before this commission voted on jurisdiction and standing. There was a meeting on October 8th in which this commission voted. Mr. Lawless, Commissioner Lawless, voted in favor of both jurisdiction and standing. This is the exact type of communication that we're entitled to know about, because this commission and everyone needs to know that this took place. But this is the sort of ex parte communication that has not been disclosed voluntarily, and that this commission, I believe, has been advised does not need to be disclosed because it doesn't explicitly relate to the merits of the appeal. That is simply wrong. This is exactly the type of communication that is necessary and relevant to demonstrate why the recusal of Commissioner Lawless is warranted, and we're
This is a continuation of the third open session meeting. We lost power due to construction in the suite next door. Hold on, please.
Speak loudly. Don't take offense to someone talking loudly. We don't have our speakers.
Okay, we're going back on the record at 12:21. Go ahead. I'm sorry.
This is exactly the type of communication that should have been disclosed, and if any such other communications exist, we're entitled to know them. To put a finer point on it, if you were in Ron's shoes, would you think it's fair that your judge, and that's what you are here today, your judge had dinner with your adversary the night before a critical hearing, and worse, that you believe that judge believed that they were not required to tell you about it? Is that the standard that this commission wants? One last brief comment. We provided this commission with questionnaires on November 17th to fill out regarding disclosing all of these communications. At that meeting, the commissioners agreed to do it. We then received communication from your counsel that you would not be filling out the questionnaires. She advised you not to, but you would be making some sort of disclosures at some future
we need
meeting.
to wrap this up now.
We request that these disclosures be made. We are not trying to trick you with the questionnaire. We're just trying to get the information to which we're entitled and to which the rest of the commissioners are entitled. Thank you.
Jim Torrey again. Ron is attacking your credibility, and he's got it all wrong. The bottom line is we don't know of any improper ex parte communications. First of all, Ron is using a bad definition of what an ex parte communication is. An actual ex parte communication is a private communication about the merits of the case. It's not talking about NFL football. It's not talking about horse racing in general. I can't speak on behalf of any of you. Ron can't speak on behalf of any of you, although he pretends to. Only you know your communications. But as far as we know, there have been no ex parte communications. What Ron is trying to do is to twist evidence and to exaggerate evidence in order to pretend that things bad happen. This is an example from his brief. I can walk over here to see it. This is what Ron writes in his brief. He says that Commissioner Lawless said this. This is a quote. At the same meeting, Lawless proclaimed that anyone, quote, can get a picture of us. And he puts in brackets McClintock, Lawless, and Jerry at Sunday afternoon. We'll pose for him. Here's what Commissioner Lawless actually said. He said, Mr. Nolan can take a picture of us, and Mr. Grossman asks, and who's the us? Commissioner Lawless said, Mr. McClintock and I. Well, Ron just adds the word Jerry to make it sound really suspicious. And that's a lot of way with all of his evidence. I urge you to look closely at his evidence. The other thing he does is he argues for the wrong standard for recusal. The rule of judicial ethics do not apply to you, no matter how many times Ron says they do. It expressly says they apply to judges. For instance, do you know the rule of ethics for judges also say that none of you can be a lawyer? So, sorry, Mr. Lawless, you can't be on the commission. It also says that none of you can be a partner in any business, an employee of any business, a manager of any business. So I hope this job pays really well for you, because you're all going to have to quit your jobs. You can't serve on this commission. It doesn't apply. It makes no sense. And finally, about this whole thing about, you didn't disclose your contacts. Well, your counsel wanted you to be able to disclose your contacts in February. When we were at a stay hearing in January, your counsel asked for an exception to the stay so that you could come in here and disclose your contacts. Ron's lawyers opposed it. Why? Because they want to be able to come in now and make an issue, oh, you haven't disclosed this, when it was them that prevented it. Thank you.
He's good.
Something trying to work.
I don't know if we blew the amp over here.
You're still good? Okay. Any discussion or further? You're hearing it fine? Okay. Any further discussion on motions 1, 2, and 3? So at this time, I think we'd entertain a motion to table them so that we can move on to the other motions.
So moved.
Okay, Mr. Lawless made a motion. Who seconded?
McClintock.
Mr. McClintock, thank you.
All in favor, say aye. Aye. Opposed? Roll call, please.
Okay. Commissioner Garay?
Yes.
Commissioner Feldmeyer?
Yes.
Commissioner Lawless?
Yes.
Commissioner Heupel?
Yes.
Commissioner McClintock?
Yes.
Motion to table carries.
Okay, thank you. I'm going to skip over 4 right now. We're going to go to 5 for all those following along here in the table of contents. Motion 5 is the institutional conflict of the Commission's denies Ron fair and due process of law and mandates refusal of the entire Commission from considering the appeal.
Stacey Harrison again on behalf of Ron Sims. Jerry misconstrues our argument here and creates a straw man argument that if the Commission has an institutional conflict of interest, it would be prohibited from making any decision concerning TP racing. We do not argue that, and we do not challenge the Commission's ability to make permitting decisions for TP racing. Our argument is that the Commission has a direct pecuniary interest in the outcome of this appeal because, as the Jerry Group has argued, Ron will shut down Turf Paradise if he remains licensed, if you don't take away his license. And Turf Paradise is responsible for 80% of this Commission's operating budget. Jerry, in fact, has made threats to shut down the track, stating that if he and Ron have to live together with this track, he will sell it, he will get rid of it, because he no longer wants it in his life. That is what Jerry personally has said to you to fearmonger and make you reverse the ALJ decision. That has created institutional bias for you, such that this Commission can no longer fairly adjudge this appeal. Moreover, there has been a prior taint way back in February of 2014. Former Chair Bert Kruglich was here, and most of you were here other than Commissioner Lawless. Heupel, excuse me. I think Commissioner Lawless was on the commission, but not Commissioner Heupel. In which he attempted to bypass Ron's right to appeal the denial to the administrative law judge and have this Commission immediately vote to deny Ron his license and deny Ron his appeal rights. When he wasn't allowed to make that motion, he then said to this entire Commission, we should have a vote and a motion for a vote of confidence for Jerry Sims. When Mr. Cruz was later deposed about that, he said he had no statutory basis to deny Ron's license, but he knew that Ron and Jerry and Director Walsh were good friends and there was a good ally there. This Commission has been unfairly tainted by the conduct of the Jerry Group and his institutional bias, and the appeal should be dismissed as well.
Can I make a point of clarification? I took Mr. Kruglick's seat, so I was not here either.
Thank you.
Okay.
The institutional conflict of interest argument is a non-starter. The law is pretty clear that this Commission would need to have a direct and personal interest in the outcome of this appeal for there to be an institutional conflict. At best, counsel is arguing for an indirect interest, meaning if Ron gets a license, TP Racing will go out of business and then you'll collect less tax. But Arizona law openly allows the Commission to make decisions that will affect TP Racing's revenue. For instance, you get to make the decision on the permit. Well, obviously that impacts the amount of RWA you'll be able to collect. You even get to set the amount of the RWA itself. So the idea that this, if this happens, then this happens, then this happens, that it will affect the RWA, I mean, it's silly. I understand they're throwing the whole kitchen sink in now to try to argue everything they can, but it's a non-starter. I just want to take, while I have a little bit more time, a minute to address something else, which is related in the sense that they gave you a book of various papers. In there is, you want to talk about a smear campaign, a whole bunch of stuff about Jerry Sims and allegations from 30 years ago that were fully investigated by ADOR and rejected by ADOR. As you very well know, Jerry Sims has been licensed ever since 2010, and in those 16 years, he's never been cited once for any wrongdoing. This is irrelevant and a smear campaign. I hope you ignore it. We have, he's just putting in this now. We had no chance to respond. We have FBI declarations saying this is all a bunch of nonsense. But you want to talk about a smear campaign, this is the guy doing the smearing. Thank you.
Do we have any discussion from the commissioners? This time I'd entertain a motion on motion 5. Actually, I mean, for me personally, I don't see a conflict of interest in here. So, can I make a motion?
Yes.
At this point in time, I'd like to make a motion that we deny the motion 5, that there's an institutional conflict of the commission denying Ron fair and due process of law and mandate recusal of the entire commission from considering the appeal.
Second.
All those in favor say aye.
Aye. Aye.
Madam Secretary?
Commissioner Garay?
Yes.
Commissioner Feldmeyer?
Yes.
Commissioner Lawless?
Yes.
Commissioner Heupel?
Yes.
Commissioner McClintock?
Yes.
Motion carries.
All right, so now we're going to come back to motion 4, and I think at this time I'd entertain a motion to go into executive session for...
Can we take it,
or,
before we go into, can we take a 2-minute break?
Sure.
And then we could come back and then go into executive session.
2-minute break.
Okay, it's 12:32. It is 12:35 and we're back into open session. So, are you inclined to go into executive session at this time, Mr. Gray?
Motion to go into executive session for item motion 4.
I'll make that motion.
I'll second it. All in favor, say aye.
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 Okay, we are ending the second part of the third open session at 12:36 and going into the third executive session. This is the fourth open session of the 643rd Arizona Racing Commission meeting held on April 14, 2016 at 1110 West Washington, Suite 250. We are on the record and beginning session at 1:05 p.m.
All right, calling us back to order. So can you please do a roll call?
Commissioner Garay?
Here.
Commissioner Feldmeyer?
Yes.
Commissioner Lawless?
Here.
Commissioner Heupel?
Here.
Commissioner McClintock?
Here.
We're back in session.
Okay, I just want to verify both recordings here. You okay? Okay, thank you. All right, with regards to motion 4, what we're... Oh, okay. We're going to give each party 5 minutes. What I will be doing is I'll be given a 30-second alert, so I'll let you know when we have 30 seconds, and then the bell will be rung at 5 minutes. So hopefully that's okay with both parties. So I'll go ahead and...
This is Stacey Harrison again. Commissioners McClintock and Lawless should voluntarily recuse themselves. If they do not, the other members of this commission should vote to disqualify them. In your booklet on page 1, there is a quote from the Attorney General Handbook that states, if disqualification of one member of a board or other multi-member entity is requested and the member refuses to recuse himself, the full membership should decide whether disqualification is appropriate without the member in question participating in that decision. So if Commissioners Lawless and McClintock refuse to recuse themselves, the three of you are required to vote and decide whether they should be disqualified without their participation. Now let me tell you why recusal or disqualification is warranted. The Commission here again is acting in a quasi-judicial manner. That means that you are governed by the same ethical rules while acting in this capacity as any decision maker or judge considering a matter in court. This is not my opinion. This is the Phillips case that is cited in the briefs that I put before you, in which the court said they see no relevant distinction between the role of a judge and that of an administrative law judge, which you are acting like today. A decision maker must recuse himself if he is not able to conduct a hearing in an impartial manner. And the standard is not simply the statutes that are cited to you on general conflict of interest in participating with the board. The Havasu case, which is cited in the Attorney General Handbook, says you need to look at whether there's bias, and not bias specific to the issue of the appeal, but bias generally, and in specific, whether there are personal attitudes towards one party or another. The Havasu case also cites a Cinderella case, which is a D.C. Circuit case that states, the test for disqualification has been succinctly stated as being whether, quote, a disinterested observer may conclude that the agency has in some measure adjudged the facts as well as the law of a particular case in advance of hearing it. So it's not whether you are involved in the business, it's whether you have bias towards one of the parties or have prejudged the case. And this is why Commissioner Lawless and Commissioner McClintock should be recused. First, Commissioner Lawless himself has acknowledged that he would be concerned if he was a litigant and saw his judge socializing with an adversary. That's reason in and of itself he should recuse, for the appearance of impropriety. We also have received no disclosure or statement that nothing happened at that dinner. I want you to think about that. No one has come out and said, I didn't discuss this appeal with Jerry Sims. We haven't heard that, and we've had no disclosures. But let me tell you why the two slides in your packet about Jerry Sims' wrongful conduct in the past are relevant. And the first one is on page 2, about Jerry's past bribery and extortion. And this isn't smear. This is relevant because this is about Jerry Sims' admitted bribery of a California coastal commissioner. This shows pattern of conduct. This shows why this commission should think that these social meetings and drinks and dinners and whatever have you that they see Jerry all the time wasn't just innocent. It's because this is what Jerry does. And this is from a Court of Appeal decision in Arizona. This has not been discredited. This is what the Court of Appeals of Arizona said. It talked about when Sims, Jerry, was granted immunity in a federal criminal investigation into Nathanson, who's a California coastal commissioner, and California State Senator Alan Robbins. Jerry admitted it to the grand jury in 1992 that the $100,000 payment was a bribe. This has not been discredited by any FBI declaration. This is admitted by Jerry Sims as to what he did back in 92. In addition, Sims admitted that he provided a check for consulting services that was paid in connection with a favorable result that Nathan, the California coastal commissioner, could obtain for him regarding the consumer fraud investigation. This is what Jerry has done in the past. Past is prologue here. It's something to keep in mind in evaluating whether you can really trust that the communications that Jerry had in these social events with these two commissioners was so innocent or perhaps was to bias them. In addition, there are text messages between McClintock and Jerry in your booklet on pages 5A and B, that discuss their personal relationship. There was chicken soup that Jerry offered to bring to McClintock in March. And more importantly, in April, during the same week in which Ron Sims was negotiating with ADOR to get his license back before the trial concluded, there's a text exchange between McClintock and Jerry in which they talk about, McClintock says he and Lawrence are in the dining room, and we have not, and he's dodged a bullet the size of Cleveland, and they said they're pulling for you. This is actual bias. There's prejudged.
I have to cut you off. Thank you.
I urge the commission to vote. Thank you.
Thank you.
There are actual cases that discuss what the standard for refusal is, and what you just heard is not it. Administrative tribunals are entitled to a presumption of honesty and integrity. That's the Hurani case. An allegation of the appearance of impropriety is not enough as a matter of law. The burden is on Ron to show that there should be recusal, and he must affirmatively show actual bias. The appellate cases, adjudicators are presumed to be fair and may be disqualified only upon a showing of actual bias. Mere speculation regarding bias, which is all Ron has done, will not suffice. He must show that the mind of the adjudicator is irrevocably closed on the subject on those particular issues being decided. And frankly, again, I don't know what your communications were. Ron doesn't, even though he pretends to. But I haven't seen anything where there was an improper ex parte communication that would require recusal. And one of the things he tries to do in his brief, he talks about in this section gifts. It says that all of you received gifts by being invited to the track. There's nothing wrong with being invited to the track. He even cites a criminal statute saying it's a class 4 felony for a commissioner to accept a bribe, suggesting that by being invited to the track, if you have attended an event at Turf Paradise or any other event, you've committed a felony. That's outrageous. But that is exactly the type of exaggeration that's going on here. We see again Jerry Sims' 30-year-old allegations. What on earth does that have to do with whether any of you your minds are irrevocably closed on a particular subject, or whether Ron has shown actual bias? What this is, plain and simple again, they like to talk about a smear campaign, but the only smearing going on is by them on everyone else. Ron loves to play the victim. Everyone is out to get it. He wants to distract from the real issues. What is the real issue in this hearing? The real issue is whether Ron is fit for a license. But he doesn't want to focus on his wrongdoing. So before it was Bert Kruglich, it was Mel McDonald, it was Mike Manning and Jerry Sims, it was the governor's office. Everyone is out to get it. Well, now you're out to get it, or at least those of you who have voted against it. You notice how even with the gifts, he mentions that you've all been invited to events, but he only targets Commissioner McClintock and Commissioner Lawless because they're the two of the ones who voted against him on standing. It is so transparent what he is doing. He is misciting evidence, exaggerating evidence, even with this Attorney General handbook that he cited, which doesn't apply. They're exaggerating that again, saying that the three of you should vote on whether Mr. McClintock and Mr. Lawless should be recused. It doesn't say that, by the way. It says that everyone else should vote on one person. But they want to exaggerate things and just stack the table in their favor. I hope you see what's going on. I think you'll see it more when you see the actual appeal. But this is the real smear campaign. Only you know your communications. I'm not going to tell you what they are. But as far as I've seen, he absolutely has not met his burden of proof that anyone needs to be recused. Thank you.
And then I'll have to allow him 30 seconds. But this will be on this.
Mr. Heupel voted against us, and we have not asked him to recuse. And just to correct one statement about Mr. Lawless's statement at the commission meeting before, where he said you can see us together all the time. It is true, he said, Mr. Clintock and I. But after that, he stated, we both lived there. We've been going there for years. It's our neighborhood OTB. Mr. Sims lives not far from there. I see Jerry all the time. So the implication was they were together, and there are pictures in your booklet about the times that they socialized together at the Armadillo Grill. Thank you.
Sure. Can I ask a question?
Absolutely.
Can I clarify a few things first, Bill?
Your call. Go ahead.
First of all, I want to clarify that Jerry Sims and I have never been to dinner alone. It's always in a group. Jerry will call and say, I'm having dinner with Bob Budoff. Would you like to go? Knowing that I like Bob, and he's a fellow horse racing fan. Next, I have never hidden my friendship with Jerry. It existed long before I was ever a commissioner. And the fact that I was elected a commissioner, I didn't turn off my friendship, but I just continued as usual. I would love to recuse myself. I'd want nothing more than to get out of reading volumes and volumes. But I am not willing to admit I'm biased or I've made up my mind. I haven't even reviewed the major portion of the record because we've been on hold in these proceedings. So I just want to make that clear. I don't, and you know, it's up to these guys, but I have to recuse because that would be an admission on my part that I'm biased, and I'm not.
Who did you have dinner with on October 7th, sir?
You know, I don't...
There'll be no questioning like that in this hearing, I'm sorry.
He said there was other people there. I thought we were entitled to know who was there. I would love to get disclosures so we can understand what full relationships are.
I mean, I understand, but it sounded like cross-examination, and at this point in time, I don't think we have that room for that. But
I don't recall because I wrote down dinner with Jerry because he's the one that called me. I've had dinner with Jerry and an array of other people. Many times. Jerry's been a guest at my house for dinner. I've been a guest at his house for dinner. We're friends. But does that mean I won't rule against him if I see something in the record? No.
I will say that I don't believe by recusing yourself you're admitting bias. Certainly, if there's an appearance of impropriety, you can recuse yourself. It doesn't mean that you're admitting to anything. But that is up to you and, of course, up to this commission.
Okay, we're over the 30 seconds, so did you okay. We have a question for you. I'm sorry.
And perhaps from both of them then. You're using the word appearance, or the definition of appearance, and bias synonymously. Are you or aren't you? I mean, I'm just in my head trying to separate it, and I hear it, you combining the two.
Impropriety and bias are synonymous. So impropriety would mean that you're a biased person in terms of whether you can fairly judge this appeal. The appearance of impropriety or bias is that a reasonable person would believe that given the relationship or communications that you have, that there is possibly bias or impropriety going on. In a court, a judge ordinarily would recuse himself if there was an appearance of impropriety, so there would be no question later on. Ultimately, you never quite know what happens between two people when they're alone or even when they're with others. So the point is that so there's no question in our justice system, a judge, even if it looks like maybe something happened, they'll recuse, and that's appearance. Does that help?
Just wanted to hear how you define it. Thank you.
Was that a question for both or just?
It can be.
Well, it's appearance of impropriety is not the standard. The quote I read before, which I could read again, an appearance of impropriety is not enough for recusal. You have to show that there's actual bias, and the burden is on the person claiming that someone should be recused to prove that with actual evidence. And as the Pavlich case says again, you have to show that someone's mind is irrevocably closed on a subject that can't be changed. They're just so far against you that they don't have an open mind on the subject. And there is no evidence of that.
Thank you. Any other questions? At this point in time, I'd like to open up the floor. If there's anyone that feels that they should recuse themselves or whatever, now would be a time. Oh wow! Would be the time to discuss, and or if you feel like you would need to go back into executive session, I would take that as well.
I don't think I need to. I'll leave it up to you guys. For the reasons I stated before, I refuse to recuse myself.
Yeah, I don't feel a bias for. I don't even know Ron. So I know Jerry because I'm involved in racing, but I don't feel biased in this instance at all. So I'm not going to recuse myself because of bias.
Madam Secretary, I have a couple questions, and I'm going to ask them, and I would like, after I ask the first one, to poll the commission, and then I have a second question that I would like then the commission poll. Again, the first question is, does any member of the commission feel that they would not be able to come to a fair or impartial ruling due to bias, prejudice, or prejudgment regarding the issue and parties involved.
Okay, my polling is, we're asking ayes or nays?
Do you feel so it would be yes or no?
Okay. Commissioner Garay?
No.
Commissioner McClintock?
No.
Commissioner Heupel?
No.
Commissioner Feldmeyer?
No.
Commissioner Lawless?
No.
Okay.
The second question is, has any member of the commission had any ex parte communications with any parties involved about the merits of this case?
Okay. Commissioner Garay?
No.
Commissioner McClintock?
No.
Commissioner Heupel?
No.
Commissioner Feldmeyer?
No.
Commissioner Lawless?
No.
Any other questions, sir?
No, that's unless anyone else has.
Anybody else?
So just as a procedural, then you need a motion from one of the three of us?
That is correct.
How this works?
To do what?
To finish this. Finish this item on the agenda that we're discussing.
Either to vote to have them.
Yeah, so I would do it one by one because the motions were against Commissioner Lawless and Commissioner McClintock. So I'd take one first, and then have the discussion. We three can vote on it, and then address the other commissioner.
So it'd be one motion for McClintock, whether to or not.
Yes, because they're not the same person. They're different.
Okay, so at this point in time, I'd entertain a motion whether to or not remove Commissioner McClintock.
I'll make a motion that we do not remove Commissioner McClintock.
I'll second it. All those in favor say aye.
I would like to make a comment before the vote. And I'll tell you that my comment is appropriate for both Mr. Lawless and McClintock. I can repeat it if necessary for the second motion. But I'll tell you, I spent a great deal of time reviewing this, made notes, struggled with it, had internal conversations about the difference between conflict and bias, and then the appearance. And I must tell you that although I believe that my two friends on this commission have left many with the appearance of impropriety, I've not seen evidence that there is direct conflict of bias. And for that reason, I'm comfortable with retaining Mr. McClintock. And Mr. Lawless as well, but for this motion, we're talking about McClintock.
And I think I would have fully agree with you, Bill, on that. I did some struggling and soul searching as I went through here, and I could find none, and that's why I wanted to personally ask every one of us whether we had, because I wanted you to be able to tell me whether you had or not. And I just couldn't find any. And to me, appearance is bad. I had a personal history of accusing somebody of doing something because I thought they were doing something just because of what I thought I saw, and it was later on found out it was nothing that I had really seen. So, while appearance can look bad, I don't think this was what it was. So, all those in favor? I think it's just the three of us on the motion.
Aye.
Aye.
Okay, Commissioner Garay?
Yes.
Commissioner Heupel?
Yes.
Commissioner Feldmeyer?
Yes.
Okay, motion carries to not remove Commissioner McClintock from this matter. Okay, we need a motion now for Commissioner Lawless.
So go ahead and entertain a motion now to either or not remove Commissioner Lawless.
I would make that motion.
And I'll second it.
Well, are we motioning to not remove him or to remove him?
Thanks.
Okay, so not remove Commissioner Lawless. Okay, just wanted to make sure the record was clear on that.
And then attached to that, then the comments that I made earlier are appropriate here as well.
Okay.
All those in favor, say aye. Aye.
Okay, the roll call, Commissioner Garay,
Yes.
Commissioner Feldmeyer,
Aye.
Commissioner Heupel.
Yes.
Okay, so that means that the commission has voted not to remove Commissioner Lawless from this matter. Okay.
All right, is there anything else on the agenda? Oh, there is?
The meeting schedule for the
Oh,
appeal
yeah.
and the scheduling of the appeal.
So do we need to go into? Or can we?
We can, if you have questions. I think staff has a few dates.
We may need to take a minute. I think Sherry left those upstairs.
Okay,
Apology.
all right.
So we'll just take a 5-minute break?
Okay. We're gonna.
Yes.
Or have we established?
We have not established any dates.
We're gonna-
We have circulated a few dates around.
Okay. So we're gonna go take a 5-minute break. It's 1:28 p.m. The time 1:35. We are now back in open session at 1:35 p.m. Go ahead.
Thank you. And right now we're discussing item B, 3 procedural issues and deadlines regarding Jerry Eastland's appeal to the Arizona Racing Commission. Did you have the dates that you would like to present? Who has the schedule?
Oh, sorry. June 27th
June 27th.
at 9 a.m. and Tuesday, June 28th at 9 a.m.
So are we?
The preference is for June 28th if you guys can make it, just because it's a Tuesday.
Are
For travel.
we're all okay?
What I miss?
The dates for
I got the calendar out here. I think you said the 27th, 28th, right?
Or it was 27th or 28th, preferably the 28th. I think that's
Okay.
One day.
Is 28th have my cover for
Yeah,
What is it today?
by phone.
The phone will be down, correct?
I'm hoping that it wasn't available today, but I was told that they were working on it, and they had ASNet, who's the state contractor for the phones, as well as building management and a couple of IT people from different agencies doing the Can You Hear Me Now skit. And so they were flipping switches in the phone closet. So they're telling me it should be up and running.
Can you do the 27th in person?
I don't have my calendar. I know I'm going away for the 4th of July.
No, he says by phone 27th and 28th and the 30th.
Okay.
So he's...
So there would be a possibility of 2 members on the phone that day, or are you going to be here?
I should be here
Okay.
that week. It's fine.
He's just saying for the next commission meeting. Telephonically.
Okay. So we shoot for then the 28th. Does that work for everyone?
20th?
At 9 a.m.?
Mm-hmm. Yes, 9 a.m.
That's a Tuesday.
Yes, sir.
Yep.
Do we need to do procedurals or?
We should probably set deadlines for the briefs, and now that we have the date, we can move backwards. So if the reply brief is submitted by 2 weeks prior to the 28th, it should give all of us enough time to review it.
That's the 14th.
Yes.
Are we limiting the number of pages?
You can.
We had talked about it.
I would like a lot more time if it's going to be something like this.
Same here.
Do you want to address? Sure.
Stacey Harrison again. I think the last time we were here, there was a discussion about unlimited briefing. I mean, the closing brief alone was 200 pages for the trial. So it probably will be something like that.
I would just ask for a little more time because I can't drop everything
Right.
and review this.
So, and you can ask TP Racing's counsel how much they anticipate, because they're actually going to file twice.
Right, it's our reply brief that's going to be filed on the 14th. Their response brief will be filed weeks before that, so you'll have more time to review their response brief. I expect we understand the burden on you for reviewing all this. We are going to try to be as brief as possible. I promise you that whatever they file, we will be significantly shorter, and we'll endeavor to be as brief as we can. The schedule we were thinking along the lines of was a June 14th reply date, but that we would have our opening brief due April 29th, which is about 2 weeks from now. Then we would give the other side about 3.5 weeks to do their response brief until May 23, and then we would have something less than that to do our reply brief June 14th. I think we're going to need a little more time to do our reply, actually, than our opening brief to address all the arguments they're going to bring up. So what I would propose is April 29th, opening brief, May 23rd, their response brief. That would give you, more than a month before the hearing, and then our reply brief on June 14th.
So that's acceptable.
And if something is very voluminous, if they can, if you guys could submit to me a flash drive, because I know that the Department of Gaming server can't take the size of emails. We can take it, and we'll be more than happy to get it into flash drives for the commission, or to have my office served with the flash drive so they could get it out to the commission members as well. That would work. Right, Cassie? Is that okay?
I'm sorry, say that one more time. I was looking at the calendar and figuring what days these were to get them.
Instead of all the paper filings, to put it on flash drive, is that better for you?
That's fine if it's fine with these guys, because then they're going to have to print it. And I don't know how comfortable they are reviewing everything digitally. I think some of them like to have the paper so they can make notes on it and flag things out easier.
That's me.
That's me too. And I'm a little combination. I will review it and then print out what I want. But I know like this last week I received a couple of emails that were I think well over 9 or 12 meg, and I couldn't open them up, and I had to ask for them to be resent in smaller
increments.
You can also do hard copies and deliver all of the exhibits to the commission's office and have them distributed.
Well, for us to distribute, Commissioner Feldmeyer's up in Prescott Valley. We can't distribute or deliver it to him at that point. I don't know if you're down in the valley to pick it up.
Come down here as little as possible.
Exactly, I know.
All right, I don't want to be inappropriate, and I don't know what the rules are. Mm-hmm. So we could deliver them directly to people's places if that is acceptable. I don't know if it is.
I'm fine with that.
That'd be great.
So I would just need from your attorney the addresses to send the materials.
Okay.
I do need a paper copy for the commission record and digital. Yeah. I need it both ways.
Yeah, copies for me. Yeah.
So.
Okay.
I can do so much on here, but after that, I got.
Your system slows and crashes. Yes.
I'll okay with delivering that?
Yeah, we'll deliver it directly, and we'll send an electronic copy and a paper copy, and you can use whichever one you want.
We'll do the same for each commissioner.
And should we get our addresses?
I can get them to Camila, and then she can convey them.
Shoot out an email, and I'll respond to it.
Okay.
I have just one more procedural issue about the briefing, since our brief is due in a couple of weeks. And that relates to what evidence we're allowed to use in this proceeding. I know the other side has talked about you can only use the evidence in the ALJ proceeding. That's how they define records. But I just don't think that's right. And it's a little interesting after they complained before that, the department didn't see all the evidence, but now they're trying to limit the evidence. The rules say nothing about this commission is only limited to reviewing materials submitted to the ALJ. But moreover, think about what this commission is. It's a public protection body. Racing is heavily regulated, and your job is to protect the public and not license unfit people. And what they're saying is, if we weren't even a party in the ALJ proceeding. They're saying if somebody decided not to put some evidence showing that Ron lied or Ron is unfit, we can't put it in. In other words, you have to ignore evidence showing that he might be unfit for a license. That makes absolutely no sense when you think about the public protection purpose. I mean, think about if we were dealing with a guy who's an accused mobster, and for whatever reason the evidence wasn't put in the ALJ proceeding, but we had dead certain smoking gun evidence that he was. Well, of course you'd want to consider that. You wouldn't want to give somebody a license who didn't deserve it. At the very least, we would like to be able to put in evidence showing a fraud on the ALJ. One of our arguments is that the reason the ALJ came up with the decision he did is because Ron and his counsel lied to the ALJ. And we think we can prove that. And we would like to be able to put in evidence to prove that. We'd also like to be able to put in the department's own records. The department has all these public records. It can certainly take notice of its own records, even if they weren't put into the ALJ proceeding. And finally, we would like to at least be able to put in documents that were talked about in the ALJ proceeding. So there's a number of instances where Ron or somebody else testified what a particular document says, but that was never put into evidence. Well, there's no good reason you shouldn't be able to see the actual document. You don't have to take his word for it. I mean, that would violate all sorts of evidentiary rules, the best evidence rule, the hearsay rule, and whatnot. So there's no law that says you're limited to the ALJ record. The only law I know of, Regulation 19.2-124.3, says the commissioner shall review the record. It doesn't say ALJ record, it says you shall review the record. It says you shall look at it. It doesn't say that's the only thing you need to look at. So with that in mind, we'd like to be able to put in materials that weren't necessarily submitted in the ALJ proceeding.
Did we, at a previous meeting, I thought we had kind of discussed this. I just don't recall.
Yeah, I don't either, but I would suggest that Camilla maybe get on a conference call with you two and you guys decide, because that's a legal issue about what we can consider and we don't have a clue.
Well, at the last meeting, I believe in November, Chair McClintock stated that the briefs would be just the record, rely just upon the record of the ALJ proceedings, and in fact there should be exhibit sites to the record. And the reason is, again, we've been through this today, that this is an appellate court. We don't have the opportunity here, if additional evidence is presented, to do anything about it. I can't bring in Ron Sims to testify before you, nor is that your role about new evidence. Who knows what it is that they're talking about? I have no idea. And that's not what happens at an appellate level. Again, this is an appeal. It's not a rehearing. The hearing has already happened. The record is already set. I don't know what they're talking about fraud on the ALJ. It's got nothing to do with anything I know about. But I do know that what you're looking at is what the ALJ looked at. And that's the requirement under the Attorney General Handbook. And that's what we relied upon when Chair McClintock made that decision back in November.
Well, I think it's a Camilla issue.
I would, how I remember the discussion is that when something is in the record, to please cite to it so we know where to look for it in the briefing. If you guys want to discuss what's the record and what's not the record, I'd be more than happy to. I do agree with Commissioner Lawless. It is a legal question. It is, and I do agree with both of you. This is an appeal, but they're not an appellate court. We're still at the agency level. We haven't reached, from an administrative law standpoint, the appeal really happens at the judicial review action in Superior Court. So agencies traditionally have been given great leeway of what to do while we're at this level. But it is a discussion that I will look into more, and I'd be more than happy well before at least your opening brief is due to talk to both of you on that if you're willing.
Yeah, I think that's the most efficient way to get it done is for you to think about it, because they both raise good points, but I don't know what it makes perfect sense that if there's something relevant that was outside of what was presented at X party or one-sided proceeding that's relevant to something in that one-sided proceeding, but I don't know if we're even allowed to consider it. So that's a you decision.
Well, we would need to vote on the rules that we would set.
No, I mean what you can do is when Ms. Harrison argues on behalf of Ron Sims and the appeal, I mean I'm sure because we don't have a page limit on the response brief. I mean she's more than she can raise any of the issues she's raised thus far. She can raise, she can do motions to strike in there. I mean, we're not limiting her, so we can address it as it moves forward.
So if we're not limiting her, then is there no limits on both of them?
Yeah, there's no page limits unless you guys wanted.
Well, I think we're not
on the issues. What issues can be brought up and what evidence? If it's not in the hearing or the record, so to speak.
I mean, this is an appeal of the director's decision, so we are, in that sense, limited to those issues that were raised in the appeal in the director's decision, which is also what the ALJ could be certified, the ALJ's recommendation. So that's the universe of issues, and I urge the parties to keep as close to that as possible, but there are not hard and fast rules of that we've been able to find thus far, and we'll keep looking of exactly what you're allowed to do. And if we find that it has to just be the record at OA, then we will confine it to that. But we haven't found anything definitive either way.
We will brief that issue for you as part of our response brief and our motions to strike.
Or you can just send me a letter before then, too.
You can do that, too.
I mean, that's...
So why did you involve in that? You and Mike?
No, Mike can't represent on this.
Yes. Michael does not.
So you'll get a letter, and then at some point in time, will you be coming back to us to make a ruling on this? And if we have to make a ruling on this, do we have to vote on it, or will you guys be able to come to an agreement?
I'm hoping we could just resolve it, because we just have we have the May meeting, but one of the briefs would already have been submitted by then. So we need to resolve that issue.
Well, maybe what we'll do is we'll put it in with the evidence that we think we can put in, and then if it gets resolved at the May meeting that we couldn't put some evidence in, then we can resubmit it without that evidence included.
That sounds fair.
And what may happen, just logistically, is I can send you a letter on the law, but when we receive the brief on April 29th, we may do a specific motion to strike on the brief based upon the law that can be ruled upon at the May hearing. Although the time frame is going to be very short with the April 29th, so we'll do our best to get it in, but it won't be 2 weeks before the meeting.
That sounds fair.
Although hopefully it's soon enough that we can have time to respond to it.
We'll have 2 weeks to do both.
Well, does that mean that on the upcoming agenda we should give them time to address any motions?
That's,
Can we put it on the agenda before?
yes.
To give
Well, it
them
has
time?
to be, yeah, it has to be on the agenda
Yeah.
for us to discuss it. So, yes.
So we can add that last minute to give them both time to talk.
Yes, but the adding it in needs to be done 2 days before the commission meeting date, so by the 10th. That way I can get the agenda properly put together and posted timely for open meeting law.
And I assume these won't be big briefs. There's either some law out there or there's not.
Oh, on the evidence, it shouldn't be long.
Well, the law, yes, the law part will not be long, but I don't know what evidence he's going to put in that I have to strike. So.
Oh, okay. Thank you.
You know, I'm all right with the hearing, because that's what we got to do. But I don't want another trial. You know, this sounds to me like we're going to open up another whole arena for which we become the administrative
No, it's really,
Okay, I mean, that's all right. That's all. You just got to hold my hand
I know
and
you're,
make sure.
yes.
Okay.
I know you're picturing walking in here and there's a witness stand and.
Yeah, I'm the witness.
That's my point. It's not supposed to be another trial, so thank you.
All right, is there anything further?
I move we adjourn. I'm hungry.
We have a second. All in favor? Aye.
Okay, meeting closes at 1:56 p.m. 56 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 p.m.